afternoon, people. Oh my goodness. It's good to see you guys. What's up, Scott McGinnis? Oh man. Yeah. So I'm gonna go over I haven't read it yet. I don't know what it consists of, but the defense filed a response yesterday um to the Commonwealth's recent filing. And the now again, I have no idea. I do think it's weird that that Judge Bev set a date. I think it is for November 13th. Set a date to talk about this motion before even hearing this response, before this response is even typed up or even filed. So it's kind of weird. Oh man, hell yeah. Yeah. Honestly, what's up, Dana? It's good to see you. Yeah, like I Jessica Fletcher, new member, thank you. And also Mom of Six became a new member as well. Awesome. Thank you guys. Yeah, I so when I came home today, I rushed home because I was thinking, whatever, I was gonna set it for 6 o'clock, this live stream, and then I was like, oh my god, you know what? If I go home and then I take a hot shower after the gym, I'm gonna pass out. I'm tired. Let me tell you guys, I am absolutely in love with Ivan Drago. I am absolutely in love with him. I am absolutely in love with the dynamic that he has with Clubber. And the first night was just pure heaven. But last night, Drago decided to step all over my face all night. All night long. Drago was stepping all over my face. And and when he got tired, he would lay down on my face. And he would chew on my ear, and his teeth are very sharp. So I didn't get a lot of sleep last night. And then I went to the gym. And then I was like, all right, screw it. I'm not even gonna shower yet. I'm gonna wait. I'm gonna do a live, and then I'll spend the rest of the night relaxing. And since I'm not eating anything fattening right now, like I can wait to eat. I prefer to eat like within an hour of my workout, but since I'm just gonna have salad, so yeah, it's I'm a little not here right now, just for the record. So now I don't know. I think Melanie Little is live right now covering the Menendez thing. Let's see what that is, because I'm kind of curious. So let's check that out real quick.
And I am going to recommend that to a court tomorrow. What that means in this particular case is that we're going to recommend to the court that the life without the possibility of parole be removed, and that they will be sentenced for murder, which, because there are two murders involved, that will be 50 years to life. However, because of their age, under the law, since they were under 26 years of age at the time that these crimes occurred, they will be eligible for parole immediately. The teams that have worked on this, on the resentencing side of it, have spent literally probably hundreds of hours by now looking at this case. These cases were originally presented on the habeas side of it, which I'll explain in a moment what that is.
Yeah. Hold on a second, buddy.
Last year, and then the request for a prosecutor-initiated resentencing occurred earlier this year. And there have been people in this office working in this case from the very beginning, as well as many other cases that we have.
All right. All right. Bukaki's missing dentures. Thank you so much. You and Aiden are my favorite assholes. Thank you for keeping it real. Thanks for sharing critter pics. My cat will be shocked when she finds out that she's not a shepherd. That's funny. Thank you so much. I appreciate it. Man, and lots of love on that community post, man. I had to post that picture because I was just like, these two, they just don't stop. They're amazing. They just like love on each other constantly. It's amazing. Except last night, Drago thought my face was the place to love on all night and jump on and step on. And yeah. And what's funny is I didn't really mind it. I just didn't get to sleep. You know what I mean? Like it was like whatever. But thank you. Wow, this guy, dude, he's killing me right now.
Files. You have to understand that the way the process works when you're talking about a resentencing under the law, it really focuses not necessarily on what the original crimes were, but it focuses on, has the person been rehabilitated, number one, and number two, can they be released safely into the community? Under that rubric, since I've been in office, we have resentenced over 300 people.
Wow.
Including 28 for murder. Only 4 have reoffended. If that was a regular recidivism rate in this country, we would be the safest nation in the world, but we know that it's not. In fact, somewhere between 40 and 50% of the people that go to prison reoffend and get rearrested. And that's why we have so many problems. However, when you look at the case of the Menendez brothers, you see 2 very young people. One was 19 and the other was 21 when they committed this horrible acts. And I want to underline, they were horrible acts. There is no excuse for murder. And I will never imply that what we're doing here is to excuse that behavior. Because even if you get abused, the right path is to call the police, seek help. But I understand also how sometimes people get desperate. We often see women, for instance, that have been battered for years, and sometimes they will murder their abuser out of desperation. And I do believe that the brothers were subjected to a tremendous amount of dysfunction in the home and molestation. But they went to prison for life without the possibility of parole, which meant that certainly under the law at that time, they had no hopes of ever getting out. They could have done what many other people do, which is basically said, you know what, I'm here for the rest of my life, so I'm going to do whatever. I'm going to misbehave, I'm going to join gangs, I'm going to live the life of the person.
Yeah, I keep hearing
they never did that.
I have thoughts on that.
To the contrary, even though they didn't think that they would ever be let free, they engaged in a different journey. A journey of redemption and a journey of rehabilitation. And often the people that begin their journey of rehabilitation and redemption in prison is often very internal in what they do. One of our lawyers,
you guys might be thinking this is taking too long, but
it's usually the path as people try to
you got to understand he's got to sell
do things for self-improvement.
He's got to.
The brothers have done, by the way, but it's more unique or less usual, I guess, when people not only do that, but they also begin to engage in ways to make life for others better. And in this case, the brothers have been doing so for a very long time, creating groups to deal with how to address untreated trauma, creating groups to deal with other inmates that have physical disabilities and may be treated differently. Even in one case, Lyle negotiating for other inmates as to the conditions that they live under during prison. And all this was done by two young people, now they're not as young, that had no hopes of ever getting out of prison. They have been in prison for nearly 35 years. I believe that they have paid their debt to society, and the system provides a vehicle
Dude, you're killing me.
for their case to be reviewed by a parole board, and if the parole concurs with my assessment, and it will be their decision, they will be released accordingly. I must underline, however, this case will be filed in court tomorrow. The final decision will be made by the judge. Court has to agree with my conclusion that they deserve to be resentenced. It is very possible that there may be members of this office that will be present in court opposing the resentencing. And they have a right to do so. And we encourage those that disagree with us to speak, and the court is the appropriate place to do it.
It's not here?
We certainly feel we're very sure not only that the brothers have rehabilitated and that they will be safe to be reintegrated in our society, but that they have paid their dues, not only for the crimes that they committed, but because of all the other things they have done to improve the life of so many others. So, again, we will be filing for resentencing tomorrow. We're seeking that they would be sentenced to life with the possibility of parole, as opposed to life without the possibility of parole, which is they currently have. That means that they would have 50 years to life because there were two murders. But because of the age upon which they were convicted, under 26, under current law, that means they're eligible for youthful parole. I think there is also important to have some introspection today, because I think that often, for cultural reasons, we don't believe victims of sexual assault, whether they're women, whether they're men.
That's not true. Come on, man. Maybe
We
back in
saw
'89.
the first trial, which, by the way, they were tried twice. The first trial hung, meaning the jury could not come to a conclusion, and in fact, about half of the jury wanted to convict them of manslaughter, which, if that were have been the case, they would have been off prison a long time ago. And then there was a second trial, and then they were convicted of murder with special circumstances, which led to the life without the possibility of parole. But it's salient to understand that our own implicit and sometimes explicit bias around sexual abuse and sexual assaults often leads us to severe injustices in our community. And I want to speak to those that are victims of sexual assault now, whether you're a man or a woman. Know that we're here for you. If you're a victim of sexual assault in this community, and by that we're talking about LA County, not just LA City, you can come for help. Whether you're prepared to prosecute or not, we will be here for you. We have services for you. And if you're prepared to move forward with the prosecution, we will evaluate it as we do any other case. And if we believe that the evidence is there, to present a credible case in front of a jury that can be proven beyond a reasonable doubt, we will proceed accordingly. You do not have to suffer alone. You don't have to keep it to yourself. And help is here unconditionally. I'm going to say a few words in Spanish because I know there's tremendous amount of interest from the Spanish media. And I know that there are
like, it sucks because what he's saying is pretty important. I just wish he would do it faster.
Primero que nada, quiero dar las gracias a todos por estar aquí hoy.
See, his English is probably just not that good because he's speaking Spanish.
Estamos hablando del caso de los hermanos Menéndez. Este fue un caso donde dos hermanos, uno de 19 y uno de 21 años,
is he going to say the whole thing in Spanish, though?
Más de 3 décadas atrás. Los muchachos fueron condenados por asesinato y llevan en la prisión alrededor de 35 años. Este fue un caso que tuvo mucha atención pública cuando sucedió y indudablemente tiene mucha atención pública hoy cuando vemos esta habitación como está llena.
He sounds Cubano, right? That Spanish sounds Cuban as fuck.
La razón por la que nosotros estamos buscando que la corte reevalúe la sentencia original es la siguiente.
Spanish sounds Cuban.
Bajo la ley de California, cuando una persona es acusada de un crimen, ese crimen puede ser reevaluado si la persona lleva muchos años en la cárcel o la prisión y enseña que se ha rehabilitado y que puede ser reintegrado en la comunidad sin causar peligro para el resto de nosotros. En el caso de los hermanos Menéndez, nosotros hemos revisado el caso y creemos, número uno, que se han rehabilitado y número dos, que pueden ser reintegrados en la comunidad sin causar peligro para el resto de nosotros. Es importante notar que este es un caso de dos muchachos que tenían 19 y 21 años, que probablemente fueron no solamente acosados por su familia, pero posiblemente también fueron molestados sexualmente.
When I was 19, I knew not to kill
Aunque no hay excusa ninguna para los crímenes que ellos cometieron, reconocemos también que habían ciertas condiciones que pueden haber creado esta situación. Desde que están en la prisión, ellos han demostrado con sus acciones y sus palabras que iban a hacer todo lo que era posible para rehabilitarse. No solamente ellos hicieron cosas para mejorar su vida personalmente, pero también tomaron parte en muchos programas y crearon programas.
Get the fuck out!
For real, dude. Jesus, bro. Oh my God. Yeah, he's just repeating everything that he just said in Spanish, understandably so. So let's take a look at the poll I put up here. Do you guys think that the Menendez brothers have served enough time since their incarceration in 1989? And 76% of you said yes, that they served their time. Now, here's the thing, is I don't really know how I feel about that just yet. Now, we're going to get into the Karen Reed stuff, I promise. And we got a small crowd today, which is interesting, but okay. So we're gonna I have mixed thoughts about this. Because the problem is that they planned this. You know, the two of them, they planned this murder. And then they went out and celebrated pretty much. They just spent a shit ton of money. They fought to get their inheritance. And they spent a shit ton of money. And I'm not saying that they weren't abused. But the problem is that they, you know, and then the other argument is, well, they've done so much in prison, you know, they've done so much good in prison. They didn't squander their time. They did good things. Well, let me tell you about a gentleman who goes by the name of Edmund Kemper. Okay. Now, some of you know who this man is. He's still alive. and he is currently incarcerated. And the interesting thing about Edmund Kemper is he's known as the co-ed killer. Okay. He was locked up back in the 70s or the 80s. I don't even remember. But Edmund Kemper was the co-ed killer. He was a serial killer, and he murdered women, and he did insanely grotesque things. Now, are his crimes much more severe than, I mean, I guess that depends. It depends on what you think. Maybe murdering your parents in cold blood is worse to you morally than being a serial killer of a bunch of strange women. I don't know. That's up to you. It's subjective. That's up to you. However you feel about it. But his final victim was his own mother, and he beheaded her. Okay. And he violated her decapitated head. Use your imagination. It's exactly what I mean, and what you're thinking are exactly the same. And he then proceeded to take her tonsils and put them in the garbage disposal. And he threw darts at her decapitated head after placing it on a mantle. Now, the thing about him is he turned himself in. Once he killed his own mother, he turned himself in. And he loved cops, by the way. He liked to hang out with cops at a cop bar. And he turned himself in, and he's a big guy. And he's incredibly intelligent. He outsmarted the cops. I believe personally that he would have never have gotten caught unless he had turned himself in. I don't think that they had the resources back then to catch someone as intelligent as he was, or as he is. I don't think that they had that at the time. And I mean, they didn't even have DNA, but during his time in prison, if you watch the TV show Mindhunter on Netflix, he's the big guy with the glasses that they would go and visit, and he would help them with their cases, right? He did help the FBI while he was incarcerated to help profile. He was actually instrumental in the technology. Well, I don't know if you want to call it a technology, the science in profiling serial killers. He was instrumental in it. So he did that, and he also recorded audiobooks for the visually impaired and made coffee mugs in his free time, crafted coffee mugs in his free time. Now, my question to you is, based on all of these things, should we let him out too? Just a question. Just a question. Now, I'm not saying they should or shouldn't let the Menendez brothers out. I'm not saying one way or the other. All I'm saying is the reasons that people are giving as to justifying changing their sentence and letting them out, they're really not much different than Edmund Kemper's, right? I mean, isn't that fair to say? They're really not that much different. So, yes. Well, the DA is recommending Ron. The DA is recommending that that the judge resentence them. And if the DA is recommending it, then chances are it's going to happen. Yeah. Now that's where I'm at on that. I was like, I was speaking to the high heavens when it came to Gypsy Rose, Gypsy Rose Blanchard, isn't that her name? I was screaming to high heaven, let her out. She didn't actually kill her mother. She helped plan it. She celebrated with her boyfriend, who she manipulated to do it, but she was a victim, right? But now that she's out and she's on social media, people are changing their minds, right? I'm not so sure. I'm not saying, oh my God, I regret feeling like they should have let her out. I'm not there yet. But I mean, I'm looking at her and I'm going, that's not the person that I thought would be let out. So, my point being is I just don't really like her, and do I think that she is capable of doing something like that again? Yes, I do. Absolutely. If she's capable of it once, she's capable of it again. Absolutely. I feel that way. Now, does it mean that she has served enough time considering the crimes that were committed against her? And then another question is, do we decide, is that something that we should factor in when it comes to someone's crimes? What kind of crimes were committed against them? If it's not in the heat of the moment, self-defense type situation. If somebody's a victim, right? I mean, they're adults, sorry to sound crude, but dad can't rape them anymore. So how's that not revenge? And since when did revenge become legal? Since when did revenge become justified in the eyes of the law anyway? You see what I'm saying? So that's why I'm not so quick to go, oh yeah, let them out. They were molested. Let them out. That's why I'm not so quick to do that, because I think of all these other factors and I take them into consideration. And you got to think, I see, and I've always been very vocal when it comes to my opinions on these things, because like I've always said that you know um sorry, I got distracted there. I've always said that once you show society that you're capable of murder, I feel like you pretty much kind of signed off on your right to be functioning in society with the rest of us. You know what I mean? There's kind of a rule amongst us in society where it's like, okay, live and let live. You know what I mean? Let live specifically means don't kill anybody. So somebody, you know what I mean? Like when somebody just when it comes to the circumstances of the Menendez brothers, the fact that they planned it, the fact that they hyped themselves up to murder their own parents, both of them, in cold blood, and then acted like they were rock stars after that, I think says a lot about their character. And I think that's something that should be considered when it comes to, I don't think that being abused as a child automatically justifies your actions. If that were the case, then we just, okay, well, how do you define abuse? You know what I mean? We just let every mass shooter justify every mass shooter. Every mass shooter that has a manifesto or something is always whining about how their mommy or their daddy didn't love them enough, and they claim that they were abused. You know what I mean? Now Now, I'm not saying that anybody who molests a kid shouldn't be fucking killed. I'm not saying that. I'm saying that these two boys were already adults and they planned to murder their parents. And that is revenge. That is revenge. And they made the decision. They said, "Hey, we're taking the risk. If we murder our parents, we could be locked up for the rest of our lives." They knew this. So, I mean, I'm the kind of guy that if they get released, it is what it is. You know what I mean? But if they don't get released, also, it is what it is. I believe in a higher power and how things work, and things are just supposed to happen the way they're supposed to happen. And I make a conscious effort to practice this mindset. And that would be the acceptance in the GLARER acronym. I just accept things. I try my best to just accept things for how they are. It is what it is, and then you adapt. But I'm definitely not on my soapbox saying let them out. They served enough time, because there's too many things that I'm taking into consideration. And by the way, Edmund Kemper was also abused by his mother. Should we let him out? So that's all I'm saying on that. What's the lack of logical comparison? I mean, give me. I mean, I feel like I spelled it out. I'm actually willing to hear some feedback on this because I realize it's a controversial issue. And I realize that there's a lot of people who disagree with me. And again, I'm not saying that they should let him out or not let him out. I'm saying that I'm just not so quick to be like, let him out, let him out. That's all I'm saying. The Menendez brothers didn't kill Coates, right? But the Menendez brothers murdered their own parents. Did they not? Did they not plan it ahead of time? Did they not party like rock stars after the fact? Were they not living their best life after this? Well, I mean, Kemper's also very honest. Kemper is that's a dude that like it's really fucked up. Aside, if you take out the factor that he was a fucking cold-blooded shitbag murderer, if you take that factor out, I like the guy. He's a likable guy. But the problem is that he's a shitbag murderer. But the thing is he's also extremely honest and extremely self-aware. That's something that you don't normally see. Ted Bundy never even admitted to his crimes, even though the evidence was overwhelming against him. Everyone knows Ted Bundy was guilty. Everyone knows that. But Ted Bundy swore to his death, swore to his electrocution that he was innocent. So see, that actually didn't happen, by the way, because you are going by the dramatization that took place on Netflix. I read that book. I read Mindhunter, actually. Well, I listened to the audiobook at the gym, but that didn't happen. That's for dramatic purposes, so that didn't happen. Yeah, and you know what? I mean, like I said, I'm not going to be upset if they let him out, but I'm damn sure not going to be upset if they don't. You know? Declare why they shouldn't be released. The new evidence was a letter written. The recipient never mentioned in the trial. Now he's dead. Okay. Right. But his mother did. His mother did, didn't she? I mean, I get what you're saying. I'm saying, I mean, you're right. I get the point that we're talking about a serial killer here, but we don't know what the Menendez brothers are capable of. If they're capable of murdering their own parents, planning it and executing it, and not showing a shred of remorse, well, I mean, who knows what they're capable of? That's my point. That's all I'm saying. I'm not saying they are or they aren't capable of, but isn't it fair to assume that they are capable of doing this again? That's all I'm saying. Bukaki's missing dentures. Thank you so much. If Sandra Birchmore killed Matthew Farwell, if that were her parent, does that make a difference in your opinion? Devil's advocate. No, I play devil's advocate all the time. We're just talking here, folks. All opinions are welcome. If Sandra Birchmore killed Matthew Farwell, if that were her parent, does it make a difference in your opinion? So you're asking if it makes a difference whether or not it was her parent, and if she killed him. So this is a double question. I mean, I don't know. I don't know. With the circumstances, I mean, if she had killed Matthew Farwell, I would believe that she is subject to the consequences of the law. Murder is murder. If she actually did it, I would definitely take into consideration all of the factors. But I mean, we're talking about an incredibly hypothetical situation here, and I mean, I don't know. I don't know. But the problem with that is we're talking about a system that would be convicting her that we know to be corrupt. So that comes into play here. So it's not really, in my opinion, a fair comparison. That's all I'm saying. I don't know. I don't know, Petty Patty. I'm not completely sure of that. Anyone is capable of it, though. Actions are what matter. I don't think they would act on it now, though, to be honest. Could just be me. No, I mean, it's not just you. There's a lot of people who feel the same way that you do, Petty Patty. There's a lot of people who feel the same way you do. And I'm actually glad that we're having this conversation. But I mean, well, sure. But I feel like we're splitting hairs, though. Like everyone here knows that everyone is physically capable of murder. Of course, that's why, you know, if you're a God-fearing person, then you believe that, you know, we're given free will. You know, so you have to take these things into consideration. Um, you know, like Clubber he doesn't have an aggressive strand of DNA in his existence. He just doesn't. Talking about half, he's 50% pit bull, right? Now, would he do whatever he needed to do to protect me? I don't even know. Because again, I've never seen him aggressive towards anything. anything. So I don't totally agree with you when you say that, anyone is capable. Is he physically capable? Absolutely. His jaw is one of the strongest. When he plays with me, I'm like, Jesus, man, I hope nobody pisses you off, but I mean, um, that's fine, Cherry. You can feel that way all you want. I'm standing by my position that being abused does not fucking justify murder. It does not fucking justify murder. Now, in the moment, in the heat of the moment, to defend yourself, absolutely. Of course. But I don't think that be saying that me saying I was abused will justify me hurting other people. It just doesn't. And yes, does it take more strength to learn from it and build yourself off of it? Sure, of course it does. But nevertheless, that's your cross to bear. You are not justified, in my opinion, to murder anybody simply because you suffered abuse in your past. Now, you guys ready to change the subject now? So let me see this here. Yeah, nobody's saying they don't get it, Cherry. I'm saying that it doesn't justify it. I understand it, you know. I understand things happening, but it doesn't mean that it's justified morally, in my opinion. And the Goodmans gifted a membership. Thank you so much. I appreciate you. Oh my goodness. Is it? There we go. Yeah, sensitive stuff, guys. Like once in a while, we're going to talk about some stuff that's kind of tough to talk about, but that's in my opinion, that's exercise for both the mind and the soul, especially if we can have a discussion, disagree, and be civil. Stacy Face Travels, thank you so much. Murder is murder. These cases, they say temporary insanity was at play, drives me crazy too. I mean, yeah, I'm not sure how I feel about the temporary insanity excuse, but at the same time, I mean, temporary insanity, I think that's too general. I think you have to with what we know about mental health now, temporary psychosis or temporary, you know what I mean? Something a little bit more specific than just temporary insanity. To me, that's a little Kellyanne Gerber, thank you so much. And thank you, Jerry, for posting that. Yeah, I mean, dude, like I get it. If somebody is, I mean, if somebody is being hurt, then and they do what they got to do to get out of that situation, then fuck it. Dude, straight up. I mean, dude, like if by some miracle, like some big dude, like some guy bigger and stronger than me fucking pointed a gun at me and by some miracle I managed to get the gun away from him, I'm shooting that fucking guy because he's bigger and stronger than me and he's already trying to kill me. So I'm fucking shooting that guy. I'm doing anything I can to put that dude the fuck down. You know what I mean? Because so if somebody is abused and they have no power, no physical power over this person, then do what you got to do. Absolutely. Allegedly, most abuse is. Most abuse is. All right. All right. So, the defense filed a response to the Commonwealth's latest last brief. And this is the reply brief of appellant Karen Reed, who appealed her case because charges 1 and 3 were allegedly voted not guilty by the jury, but that never got discussed, that never got brought up. And we talked a lot about that. We've talked a lot about that. So I'll just start reading this. And I want to be able to skip through all of the refreshing of the case, and it looks like they just didn't even, okay, let's just do it then. Ms. Reed's motion to dismiss is predicated upon post-trial statements of 5 jurors, 4 directly and 1 indirectly, that the jury reached a final unanimous decision to acquit her of second-degree murder. In the usual course, that verdict would have been announced in open court, and re-prosecution for that charge would be constitutionally prohibited. Here, however, the trial court failed to inquire pursuant to Massachusetts criminal blah, 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 regarding the existence of any partial verdicts, and for that reason, the jury acquittal was not announced. The Commonwealth's argument that this court should defer to the trial judge regarding the necessity of a mistrial seeks to inappropriately bypass the clear prerequisites that have been in place for almost 4 decades, that before the declaration of a mistrial, counsel must be given full opportunity to be heard. And 2, the trial judge must give careful consideration to alternatives to a mistrial, which she did not do. Judge Bev did not do that. Referring to these 2 considerations as principles guiding or review, here there is no indication that the court gave any consideration to alternatives, most notably inquiry regarding partial verdicts, and counsel was not given a full opportunity to be heard. The court never asked for counsel's views or even mentioned the word mistrial before sua sponte declaring one in open court. So this is great because I mean, this is what we've been talking about. We've been talking about this entire time. The defense's argument, Karen Reed's argument here is that Judge Bev didn't even give the jury an opportunity to specify which counts. She didn't instruct them to specify which counts, which is her responsibility. Which is why they went to the SJC. This is her responsibility to make sure that the jury knows that there are these separate counts here and they need to come to a unanimous decision or do their best to come to a unanimous decision on each count. She never did this. And in the paperwork, the very confusing paperwork, there was not even a option to check not guilty, which they argued about during trial. They argued about it. I agree, Scott. Bev is dirty as fuck. The Commonwealth's attempt to shift blame for these omissions to Miss Reed and her counsel utterly neglects the black letter law, because that's what they were trying to say. Is they're trying to say that because they never objected to it and they just let it go, that it's the defense's fault. Well, you never spoke up. So, I mean, dude, how is that even a thing? How the fuck is that even a thing? Well, you never spoke up. So, you know, don't be a sore loser. Don't be a scrub is the Commonwealth's approach to this. Quit being scrubs. Take the L. The defense independently maintains that a jury's final unanimous agreement that Ms. Reed is not guilty constitutes an acquittal for double jeopardy purposes, and that the trustworthy and uncontradicted post-trial affidavits entitle her to a judicial inquiry on this issue. There is no precedent for the Commonwealth's contention that the lack of formal announcement alone can overcome the defendant's fundamental right not to be tried in a second time for a murder that a jury already determined she did not commit. The Commonwealth did not satisfy its burden of establishing manifest necessity. As noted in Ms. Reed's opening brief, this court reviews determinations regarding double jeopardy de novo. Defense brief 21, quoting Taylor, blah, blah, blah. While the court has sometimes reviewed determinations regarding manifest necessity for abuse of discretion, such appellate deference will be accorded only if the record reflects that the trial judge gave reasoned consideration to the various available alternatives. If the record reveals that the trial judge has failed to exercise the sound discretion entrusted to him, the reason for deference by an appellate court disappears. Here, it is not clear from the record that the judge gave careful consideration to the available alternatives and to the defendant's interest in having the trial concluded in a single proceeding, and accordingly, the abuse of discretion standard does not apply. So they're saying, I mean, she did not live up to her responsibilities, is what it boils down to. Remember months ago, I was saying, well, she's never gonna, you know, she's never gonna rule in favor of the defense's motions when these because these jurors came forward. That means that she'd have to admit to wrongdoing. Remember I said that? She would have to admit to wrongdoing. Judge Bev, there's nothing about Judge Bev that indicates to me that she's capable of admitting any wrongdoing, taking any accountability here. Every single decision that I've seen her make in some way, shape, or form has been outside of the interest of justice. So I don't trust anything that she's ever said or done. And as soon as this happened, I was like, and I know that of course the defense felt the same way. The defense is like, of course she's not going to rule in favor of us. This was rigged. Now, I don't know if the defense feels like it was rigged. I have no idea. But I fucking feel that way. This was a rigged game. Judge Bev is the Nurse Ratchet of this trial. She likes a rigged game. And she's been rigging this game since pre-trial. And I feel perfectly comfortable saying that at this point. I mean, the thing is I mean, she's still presiding over this case. There's nothing that could really be done about it. Hopefully they can get those 2 counts dropped over Bev's head. Hopefully when they go over Bev's head here, they can get those 2 charges dropped, and then they'll just be trying a involuntary manslaughter case, which is fucking I mean, it's insane. Like, you can't convict on that. There's not even enough evidence that's like, it's going to be really easy for the defense to even just poke holes through that. And it's going to, like, they have to justify to the public that they're moving forward with this farce of a case. If those 2 counts are dropped, they have to justify it to the public. It's now been very public now. Mainstream media picked up on the rubber ducky scandal. Now the world is looking, wait, what? Rubber duckies? What the fuck is going on? And all it takes is for somebody to do just a little bit of homework and realize that there was vastly more effort into the investigation of the great ducky caper than there was into the investigation of Boston police officer John O'Keefe's murder. I mean, there's a vast difference. So Karen Reed's defense is basically just saying now what we've been saying this entire time. Like, it was on Judge Bev to instruct this jury that there were 3 separate counts here and to specify on those counts. You can't put that shit on us that we didn't object because you didn't do your fucking job. The Commonwealth's heavy reliance upon purported discretion without acknowledging the foregoing principles represents an attempt to bypass the 2 guideposts that have governed this court's manifest necessity jurisprudence for nearly 40 years. Count 1, counsel must be given full opportunity to be heard, and 2, the trial judge must give careful consideration to alternatives to a mistrial. Contrary to the Commonwealth's suggestion, resolution of these issues does not depend upon any credibility determination. Commonwealth, blah, blah, blah. Rather, the court must simply determine whether the record in this case satisfies the applicable standard as construed by its precedents. So, they're saying here that she also never gave the defense ample time to be heard on the issue. That they were never presented. They were never presented with anything, and they never had an opportunity. I mean, it just all happened so fast. Okay, folks, I'm not going to do that to you, folks. Your service is complete. I'm declaring a mistrial. And that was it. And everybody was just kind of sick of being there and going, okay, what do we do next? At that point, like, she pulled such a fast one that at that point, even the defense was like, okay, so what's our next move? That's what Karen Reed pays them for. To go, what's our next move? She declared a mistrial. It's done. What's our next move? Not, hold on, wait a second. Let's assess what just happened here. Because that could happen too. But you cannot put the accountability on the defense for being duped by the judge. Because the judge just hauled ass through everything. Mo man, thank you so much. I appreciate you. She just hauled ass through everything to get the fuck out of there. And everybody was just kind of, it happened so fast, they didn't know how to process that. And that's just not something that you see a fucking judge do. You know what I mean? So, like, how many times during pretrial did you see David Iannetti and or Alan Jackson just completely dumbfounded as to what the fuck Bev just did? It happened more than once where they were just, your honor, wait, I've never seen what is going on here? So at this point, I mean, how are they going to process that, dude? That's something that's uncharted territory. They've never seen that shit before. They've never seen a judge do that shit. Think about it. Dude, I watched this documentary years ago called What the Bleep Do We Know? In one example, it was about quantum physics and shit. I'm not going to get all into it, but it's really interesting. It's a cool documentary. And there's all these quantum physicists that are talking through it and whatever. And one of them used this analogy about how there's a legend that Native Americans, when Columbus and everybody were just showing up, they're huge, like the Mayflower being massive, this massive vessel, like people couldn't see it. The Native Americans couldn't see it until it was right up close, right in front of them, because they had no frame of reference to visualize and compare it to. They didn't know anything like that even existed. The technology was way beyond anything that these people had ever imagined. Right? So because that they had no way to process this, like their eyes didn't register this massive vessel that they had no idea how to, the technology was way too beyond for them. Right? Now, I'm not sure if that's true, but it's kind of the same thing in a way. It's just like, what do you like? It's a fucking Jedi mind trick. A judge doing some fucking wild ass cowboy Wild West shit like she just did is not something that two very professional attorneys are going to just like catch and be like, the fuck was that? I mean, yeah, this is it sucks because like I swear they've written this before. They just have to keep doing this because now they've got this fucking mob shyster to prosecute an unwinnable case, because that's not suspicious in and of itself. Rather, the court must simply determine whether or not, okay, nothing in the Commonwealth brief justifies the trial court's failure to consider the alternative of inquiring regarding the existence of any partial verdicts. While the timing of whether to accept a partial verdict is ordinarily discretionary, requires the trial court to accept such partial verdicts before declaring a mistrial, meaning it was her fucking job based on Rule 27B right here, C Massachusetts, R criminal P27, whatever the fuck that means. But this is what they're citing because there is clearly a law that dictates that she has to give those instructions to the jury before she declares a mistrial. I mean, unreal, man. This rule provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive the record and verdicts which the jury can agree upon. None of the cases cited by the Commonwealth is to the contrary. In two of those cases, the jury expressly indicated it was deadlocked on all counts. Now, I'd have to compare and read the Commonwealth's brief again to compare them, but Fuentes versus Commonwealth, blah, blah, blah. Note stated that the jury could not reach a unanimous verdict as to either of the two indictments. Daniels versus Commonwealth, jury said further deliberation will not yield a unanimous verdict on any indictments. And defense counsel, having been provided an opportunity to respond, agreed that the jury was at an impasse on all indictments and said he had no objection to mistrial. In these circumstances, inquiry regarding partial verdicts is understandably not required. But here, the jury never specified or was asked to specify on which counts it had reached an impasse, nor had counsel consented, as in Daniels, to a mistrial. So that's interesting right there. So they're saying that it just never, the difference between these cases that the Commonwealth tried to cite, this case they tried to cite, they're saying that well, the same thing happened and it was just declared a mistrial and it was what it was. But the problem is that it was specified that there were separate counts and they were at an impasse on all those separate counts, that the jury was made aware by the judge about those separate counts, those separate charges. So, I mean, it's not comparable. The whole argument that the defense has here is you never even told the jury to make sure that you went over each charge to come to a decision, to come to a unanimous decision on each charge, each individual charge. So 3 unanimous decisions here. Bluford versus Arkansas. It also readily distinguishable. Their state law prohibits a partial acquittal for offenses included within a single charge. Here, in contrast, it is clear that Rule 27B permits taking verdicts on less than all of the charges set forth in separate indictments. Commonfilth versus Roth. Roth and a juvenile like Bluford involved lesser included offenses within a single count and are thus in opposite as to whether the court should have considered the possibility of partial verdicts on separate counts under Rule 27B. As set forth above, because the record reflects no consideration of alternatives to a mistrial, this court should not defer to the trials court's construction of the jury notes. In any event, the notes were readily susceptible to a reading consistent with the post-trial juror statements. The first note, stating the jury was unable to reach a unanimous verdict, did not preclude the existence of final unanimous agreement on some but not all counts, particularly in the context of the court prior instruction to continue deliberating until you have reached a final verdict on each charge, quote unquote. The Commonwealth states that the defense's reading of the notes, quote unquote, is not the more natural and straightforward. Quote, is not the more natural and straightforward, end quote, but it does not explain why the defendant's alternative and, in retrospect, correct reading is not reasonable. Alternative that the court completely failed to consider. The Commonwealth cries no authority for its contention that it is necessarily coercive for a court to inquire regarding the possibility of partial verdicts on separate indictments. Indeed, the case law holds that such inquiry is not coercive. Right, it's not at all. So they're trying to argue that the judge can't overstep her and abuse her power by asking what took place during deliberations. Okay? Now, the interesting and fun thing about that is that's not what the defense is asking her to do. They're simply asking her, and that's all they've ever done, is asked her to ask each individual juror what their vote was, guilty or not guilty. That's all they're asking Judge Bev to do. That's all they've ever asked Judge Bev to do, is to put these jurors in a deposition or on the stand, whatever, and ask them individually what their vote was, not how they came to that vote, not what persuaded them to, and not what they struggled with. And I felt this way, and then I felt that way. They're not asking her to do all that. They're asking her to simply ask guilty, not guilty on which of these 3 counts, on all of these 3 counts. individually, specifically guilty or not guilty. What was your vote? That's it. That is not unreasonable. So it's interesting to me that I can understand this, but the Commonwealth writes these briefs and file these motions prior to that, and they don't seem to understand this argument, even though we've heard this argument many times, even though I am the laymanest of the laymans, okay? And I understand this issue. I understood it as it was happening. So how is it that attorneys, where this is their trade, don't understand this? Whether it be Lally, or whether it be Bev, or whether it be Brennan. I mean, how is it that I understand this, but they don't? Because they're just not, it seems like they're having two separate conversations. The judge cannot inquire as to what happened in deliberations. Nobody's asking her to. At no point did they ask her to. At no point did they file a motion asking her to do that. It never happened. The Commonwealth claims Foster and LaFontaine are inopposite because neither of these juries reported being deadlocked. But Roth cited both these cases in the context of a deadlock for the proposition that partial verdicts are permissible when they are separate indictments rather than a single indictment. Commonwealth versus Floyd, acknowledging authority to accept partial verdicts from jury deadlocked on one but not all counts. The trial court's failure to consider inquiry regarding partial verdicts cannot be excused based on speculation that defense counsel may have objected to such inquiry when in fact defense counsel never did. Right. So you can't just go off the assumption that they may have objected to this inquiry, and they never did. The court could and should have raised the issue with parties and considered their respective views.
I think we got a super chat.
Super bad.
I think we got a super chat.
Super bad.
Super chat.
Super
Super
bad.
chat. I think we got a super chat. I think we got a super chat.
Local horse, thank you. Will they understand it? Believe me, you. They're simply corrupt. Exactly. I mean, this is all a sham. Like, it's just so funny to me that this is all, like, the more this goes on, there's no way that the more this goes on, the Commonwealth can make this look any more legit. Their only way it could happen is if the longer it goes on, what is inevitable is that it's going to look more and more like a sham. It's being exposed more and more like a sham because more and more information keeps coming out that is more and more exculpatory to Karen Reed. And anything exculpatory to Turtle Boy at this point is exculpatory to Karen Reed to some degree. It just all depends on how it's presented. I absolutely believe this. Because think about that. Now, before I forget, Turtle Boy's going to be on 13th Juror Brandy Churchwell's channel at 8 p.m. Eastern tonight. So you don't want to miss that. Now, with what we've been seeing in the Betterow letters, right? The infamous Betterow letters. These things are things of legend at this point. these better row letters. And what we're seeing is that, and I've explained this before, but I'm going to explain it one more time to give you guys the perspective that I'm trying to just to properly paint the picture I'm trying to right now. When I say that anything exculpatory to Turtle Boy to some degree is exculpatory to Karen Reed. This is why. Because right now, Turtle Boy is on the verge. Turtle Boy and his defense team, the Killer Bees, Mark Betterow and Tim Bradle, they are on the verge right now of proving that Detective Lieutenant Brian Tully and Special Prosecutor to the Norfolk County District Attorney's Office, Ken Mello, colluded with enemies who are emotionally involved with Turtle Boy. When I say emotionally involved, I mean that they hate them, because we've just seen, now it's just been exposed that this woman, Krusty Patties, there's a video now circulating on Twitter of her admitting. Matter of fact, I'll pull it up right now. Because I find it, it's just so much fun, you know? Oh my God, where is it? I could have sworn I reposted it. Now I'm like, did I repost it? Maybe I didn't repost it. I don't know. Did I repost it? Okay, maybe, hold on. Okay, here we go. Here we go.
So I set out to investigate that a little bit further and see if I could draw a nexus between Turtle Boy and Karen Reed, and I could. So when I started getting this information in and kind of figuring this boy pretty much, and that didn't happen. So I ended up getting
the Karen Reed trial. And how did you get interested?
Some emails from some members of John O'Keefe's family. They had read
is the Karen Reed trial. And how did you
a blog series that I had written on Turtle Boy maybe 2-3 years ago.
You get interested? You seem to know everything about this case. How did you get interested, and how do you seem to know everything about this case?
And they originally came to me in my email and said, "Hey, do you have any more dirt on this guy? He's terrorizing our family." So I hate Turtle Boy.
Is the Karen Reed trial. And how did you get interested? You seem to know everything about this case. How did you get interested, and how do you seem to know everything about this
family? My insert relative here was murdered, and this is what happened. And at first I said, well,
I have to stop those.
Bring this out. I didn't necessarily. So I hate Turtle Boy.
is the Karen Reed trial. And how did you get interested? You seem to know everything about this case. How did you get interested, and how do you seem to know everything about this case?
So I hate Turtle Boy.
Is the Karen Reed trial. And how did you get interested? You seem to know everything about this case.
Sorry about your loss. That's pretty awful. I would not suggest, slinging mud with this guy. And R.I.P. Turtle Boy, pretty much. And that didn't happen. So I ended up getting some emails from some members of John O'Keefe's family. They had read a blog series that I had written on Turtle Boy maybe 2-3 years ago. And they originally came to me in my email and said, "Hey, do you have any more dirt on this guy? He's terrorizing our family. My insert relative here was murdered, and this is what happened." And at first I said, well, sorry about your loss. That's pretty awful. I would not suggest, slinging mud with this guy. Good luck in your endeavors. And then I started following along a little bit more, and I saw the insane amount of just witness intimidation that was coming out of this, right? Necessarily publish all of it. I brought it over to the authority. So I set out to investigate that a little bit further and see if I could draw a nexus between Turtle Boy and Karen Reed, and I could. So when I started getting this information in and kind of figuring this out, I didn't necessarily publish all of it. I brought it over to the authorities, and fast forward to now, we have several indictments and hopefully more coming. So I said.
So, in the very same conversation here, she admits to. In the very same stream that she's on there, she admits to getting involved in the Karen Reed case because she hates Turtle Boy. Like, flat out admits it. This is what we've been accusing these people of this entire time, saying these people don't give a shit about John O'Keefe. These people hate Turtle Boy. And because Turtle Boy is saying that Karen Reed is innocent, they have to say that she's guilty. That's it. That's the basis of their argument, because all of logic dictates that Karen Reed is innocent. All of the evidence dictates it. You could trace Plevin back to this. You could trace her back to it. Every single person, Grant, Wendy Murphy, all of them. Twattendorfer, all of them. They all just hate Turtle Boy. That's not an argument to say that Karen Reed is guilty in any way, shape, or form. So here, they're proving it. Yuri's math teacher, oh my God, gifted 10 memberships. Oh my God, Yuri's math teacher, amazing. Yeah, man, this is you have to be like, you have to be a fucking moron at this point, like to believe that Karen Reed is guilty. To like believe it. You know what I mean? I'm not saying that you're a fucking moron if you're just starting to follow the case and you got questions. There's nothing wrong with that. I encourage you. But if you have been following this case and you are absolutely privy to everything and all of the updates, and you think that Karen Reed is guilty still, you are fucking dumb. I mean, just fucking stupid. There's no fucking way. Just willfully ignorant, fucking retarded, AKA. You are absolutely that. And I can't even hold back when I say shit like that, because there's so much evidence to indicate. And you look at the way that this case is being handled. I mean, so to go back to my original point, these people that Turtle Boy and his team, his defense team, the Killer Bees, can prove now is that the very same people, this very same district attorney's office that is prosecuting the Karen Reed case unjustly, those very same people who he has been trying to prove conspired to frame Karen Reed, he can now prove that those very same people conspired to frame him. They proved his case for him. This is going to be amazing. So therefore, the fact that he can prove that the very people he was trying to prove framed Karen Reed, he can prove that they framed him. Karen Reed's defense team can most likely use whatever Turtle Boy's case comes up with here. Most likely. I mean, I don't know, but it feels like there's a whole lot to choose from. Feels like there's a whole lot. Alan Jackson, David Unetti, Marty Weinberg, Elizabeth Little, they can or lies a little, they can all work with. It's what it feels like. It's amazing. So that's what I mean why Turtle Boy's case, if anything that's exculpatory for Turtle Boy is potentially exculpatory for Karen Reed. Thanks to these corrupt fucks who can't even do this shit right. Glamasus, thank you so much. Krusty decided to sell t-shirts for John. Shirt plus shipping and handling was $43. And she said no profit. That link is now down. I enjoyed that way too much. Right. I mean, come on, dude. Come on. Like, you're not fooling anybody anymore. Krusty Panties, Plevin. Like, it's over. It's over. Everyone is on to you. Now the world is watching the Massachusetts State Police and the Norfolk County DA's office because they put far more resources into investigating rubber duckies than they did a Boston police officer who was murdered. The world is now watching. It's happening. The walls are closing in on these dirty fucks. This is precisely what the two here. Let me read that sentence again. The court could and should have raised the issue with the parties and considered their respective views. This is precisely what the two-pronged Stewart-Taylor test requires. Defense counsel's earlier argument regarding the propriety of the count 2 verdict form, which the trial court ultimately agreed, did not excuse the judge from complying with the court's manifest necessity jurisprudence. Another alternative to a mistrial was to poll the jury. The record reflects no consideration of that alternative either. The Commonwealth follows because here's the thing. Look, they're at this point, they're not, this isn't a letter to Judge Bev. This isn't a response. This is, I mean, this is what they're going to take to the SJC, dude. This is it. Like, they want, I mean, this is all about just getting those charges dropped from Karen because a jury acquitted her of those 2 charges. Plain and simple. Ditto, thank you so much. I appreciate you. I mean, that it's undeniable at this point. The Commonwealth follows the trial's court lead in utterly failing to acknowledge the clear and long-standing case law placing the burden of establishing manifest necessity squarely and exclusively on the Commonwealth, the party seeking retrial. Indeed, the Commonwealth brief fails to so much as mention the applicable burden or to cite Commonwealth versus Nicole, which the defense brief discussed. The defense brief discussed at length on this issue. Excuse me. I'm sorry. The trial court's misallocation of the burden constitutes legal error requiring reversal. The record is simply, Jesus, I don't know what's happening in my eyes right now. The record is similarly lacking on the second Stewart-Taylor requirement, the opportunity to be heard. The Commonwealth does not dispute because it cannot that the trial court never asked counsel for their views regarding a mistrial. In fact, the first time the word mistrial appears in the record is when it was declared in open court. The court's sal sponte action in those circumstances was aptly described as sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. Quoting Commonwealth versus Horrigan. The Commonwealth cites no comparable case finding the requirement of an opportunity to be heard satisfied. Video footage reinforces the suddenness of the court's action and corresponding lack of any meaningful opportunity to be heard. At the approximately 5:47:25 mark of the video, the court took the bench and stated, the jury is at an impasse. At approximately 5:47:55, A mere 30 seconds later, a jury arrived in the courtroom. Court then read the note, which had not previously been provided to read to counsel on the record. Oh, good point. Okay, so they're pointing out the fact that she never even gave them an opportunity. Like, hold on, we got a note from the jury. Let's read the note from the jury and let's discuss it. Like, why didn't she? I'm calling a sidebar. I'll see counsel at sidebar. She didn't do that. There was no discussion on these notes from the jury and the jury foreman. The court then read the note, which had not previously been provided or read to counsel on the record. The court stated it was declaring a mistrial and immediately discharged the jury at 5:49:30 at mere 7 seconds later. To suggest that counsel must have lodged an objection within this brief interval, or the counsel had any, much less a full opportunity to take a position or even communicate with their client, underestimates or ignores the difficulty of reaching a decision in which the defendant has an evident personal stake, whether the defense would be advantaged or the opposite by a second trial. Legal and factual context renders the trial court's action even more unexpected. Legally, trial counsel was entitled to rely on decades of case law expressly requiring a full opportunity to be heard before declaration of a mistrial. Factually, in response to multiple prior jury notes in this case, the trial court had advised counsel of the contents and afforded them time first to consider and then be heard regarding any issues raised. The trial court's deviation from that well-known and accepted practice with respect to the final note was indeed sudden and unexpected. The court should reject the Commonwealth's attempt to conflate a request for a Tui Rodriguez charge with a request for a mistrial. As the Commonwealth acknowledges, a Tui Rodriguez charge is designed to encourage a jury to consider seriously and with an open mind the views and arguments of each member, with the ultimate goal of reaching a verdict. Importantly, a Tui Rodriguez instruction is not necessary prerequisite for a mistrial. If the defense wanted a mistrial, it could have simply requested one, which it undisputably never did. Counsel was not required to affirmatively exhibit any curiosity about the extent of the jury's deadlock until that deadlock had been firmly established. It was at that point, before declaring a mistrial, that the court was required to receive and record the verdicts which the jury could agree upon. I mean, this is just providing in detail why the Commonwealth's little brief was complete and utter bullshit. GL 2234A 68C provides that if the jury reports an impasse after a Tui Rodriguez instruction, they shall not be sent out again without their own consent. The Commonwealth does not explain how this statute would in any respect impact the court's ability to simply ask the jury whether it had reached any partial verdicts. Moreover, as explained in Ms. Reed's opening brief, the court could have alternatively informed the jury that it could not be required to continue deliberations without its consent, and still asked it to retire to consider whether it was prepared, same thing, to return any partial verdict. And citing Commonwealth versus Jenkins, the Commonwealth does not respond to the defense argument on this point. Commonwealth cites no authority for its suggestion that an opportunity to be heard after the jury had been discharged somehow sufficient to support manifest necessity. Fuentes suggests such after-the-fact opportunity is not sufficient, observing the more prudent course would have been to consult with counsel before declaring mistrial, notwithstanding the court gave the parties an opportunity to be heard after the jury were dismissed. The Commonwealth's contention that Ms. Reed consented to the mistrial is based on the unsupported assertion that defense counsel consistently sought a mistrial. That is absolute bullshit. I agree. That's just plain not true. They did not consistently seek a mistrial. Commonwealth, let's see. It bears repeating that neither Miss Reed nor her counsel ever requested a mistrial. Instead, by requesting a Tui Rodriguez charge, counsel indicated that they wanted the jury to be instructed to try to reach a verdict rather than consenting to the ordeal and risks of a second trial. The defense argued that Miss Reed's personal consent was required at the Superior Court hearing on her motion to dismiss. Counsel stated that after the final jury note, there was no opportunity for trial counsel to speak to Miss Reed. After all, it's her rights, not just theirs. The defense contends that this was sufficient to preserve the argument that Miss Reed's personal consent was required. At the very least, it was sufficient to preserve the contention that an opportunity to be heard must be, in order to be meaningful, occur after a reasonable opportunity for counsel to consult with their client, and the Commonwealth does not suggest otherwise. So yeah, there was no opportunity. There was no point where Judge Bev was like, all right, so would you like to confer with your client right now? Let's take a recess and you confer with your client right now as to, what you guys want to do. Yeah. And then, Lally takes a smoke break while everybody figures out what the fuck they're going to do before she declares a mistrial. So she never, it just fucking happened. That's what's so bizarre about it. It just happened. Right. They asked for the charges to be dismissed. Exactly, ditto. They asked for the charges to be dismissed several times. They motioned for Judge Bev to recuse herself at one point. And early on in pretrial. Yeah, I was supposed to. Give me a second here. All right. So yeah, if you want to donate to Karen's defense fund, I just pinned the link to the top of the chat. I completely agree, Olivia Nile. The fix has been in, man. The fix has been in here. Like this, and I want to know, like, exactly. So here's the thing, and I don't want to speak for Howie Carr or his source, but I'm under the impression that Howie Carr felt confident posting what he posted because that's the general procedure when someone ages out of that position, right? They're moved to another county. That's it. They're done, right? So it's a safe assumption between Howie Carr and Howie Carr's source that Judge Bev was no longer going to be presiding, over the Karen Reed trial. It's a safe assumption. So what are the exceptional circumstances that they stated? Because there are there's exceptional circumstances. What are those exceptional circumstances where Judge Bev doesn't have to age out her position in Norfolk County? Yeah, thank you, Cherry. Appreciate it. Just not at the RAJ, right? But I mean, she wouldn't. They would have rehomed her. They would have rehomed her, supposedly. That's the procedure, right? That's in the statement that Norfolk County made, isn't it? Yeah, this is. I mean, there's no like you're not there's you're not gonna feed me shit and tell me that it's a chocolate cake, man. You know what I mean? Like I'm not falling for this shit. This is terrible. The jury's unanimous conclusion following the trial that Miss Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes re-prosecution. For more than a century, binding case law has warned against the exaltation of form over substance in determining what constitutes an acquittal for double jeopardy purposes. See Ball versus United States. However, it may be in England, in this country, a verdict of acquittal, although not followed by any judgment, is a bar to a subsequent prosecution for the same offense. While many of these cases have arisen in the context of judicial acquittals, the Commonwealth does not explain why form should outweigh substance with respect to jury acquittals. See Roth, 437 Mass at 796, rejecting Commonwealth argument that quote unquote would elevate form over substance. Indeed, the double jeopardy clause prohibits re-examination of a court decreed acquittal to the same extent it prohibits re-examination of an acquittal by jury verdict. Smith versus Massachusetts. The Supreme Court has, for example, consistently refused to rule that jeopardy for an offense continues after an acquittal, whether that acquittal express or implied by a conviction on a lesser included offense. Now, what I'm seeing here is just they're citing law after law, example after example, like case after case, explaining why this is totally like, I mean, it's your American right. Jurors came forward. Nobody sought these jurors out. These jurors came forward on their own, independently, came forward and said, hey, something's fucking wrong here. Okay. It's really important. I don't feel like, the Judge Bev's actions actually inspired this to happen. The fact that Judge Bev never gave them the opportunity is what made them go, you know what? We got to come forward. We got to say something. We got to reach out to both the Commonwealth and the defense and let them know what actually happened back there. Some of them we were like, we got to talk to Turtle Boy because something's wrong here. So to me, that speaks volumes in and of itself. That speaks volumes. And they're saying something's not right here. We feel that it's our duty as jurors. Our duty was not complete. Our duty is only complete that we came forward and told you that specifically on counts 1 and 3, we found her not guilty. There's got to be some way to correct this issue. That's what those jurors, that's what was in their heart. And that's what was in their mind, to come forward and do the right thing because they felt as their duty as jurors that the right people needed to know that this woman was found unanimously not guilty on 2 of those counts. That speaks volumes. That should be enough for Judge Bev to say, if Judge Bev was If she were acting in the interest of justice, Judge Bev would simply say, okay, well then, you know what? I'm gonna at least talk to these jurors. I'm gonna at least talk to them. Okay? Y'all need to just fucking chill the fuck out. Just wait. All right? And I'm gonna get to the bottom of this. But she never even made that effort. The fact that she failed to even make that effort is what tells me that she is fucking dirty. Because if you were acting in the interest of justice, you would investigate this issue. Somebody's rights and somebody's freedom is at stake here. And you swore an oath to defend those rights. Yeah, you're not going to, I'm not eating this shit sandwich, dude. I'm not doing it. I mean, there's no way you're going to tell me that this woman is not corrupt. No, I mean, you can't prove it. You can't prove it. But it's clear. It's obvious. I mean, dude, if you take all of it's one of those things where you just fucking know it. You know what I mean? You have enough circumstantial evidence that you're naive if you think otherwise. It's to that point. It's to that level where there's so much circumstantial evidence to indicate that Judge Beverly Cannoni is not acting in the interest of justice and has some other fucking motivation, whatever it is. There's enough to tell you that. Her actions tell you this. That is corrupt. If you are not active, you are consistently making decisions that are not in the interest of justice when it is your job and your duty to make decisions in the interest of justice, then that tells me that you are corrupted at your job. That means that you are corrupt. Your job is corrupted. Your job title is corrupted. You are corrupt. I mean, and you take everything you take everything around it, the circumstantial evidence, the fact that she has ties to the McAlberts, which came out way early in pre-trial. Way early in pre-trial. I don't need proof other than, I mean, you're going to tell me that her decision making throughout pre-trial and throughout the trial, that's not proof in and of itself of corruption? If she's not acting in the interest of justice, then she's corrupt. Period. That's it. She's abusing her power. Despite the defense repeatedly pointing out the absence of contrary authority, the Commonwealth still cites no case in which a defendant was forced to stand trial a second time for an offense a previous jury had found her not guilty of, simply because a final unanimous agreement was not announced in open court. United States versus Dotson. Affirming correction of a verdict on one count after receiving telephone call from two of the jurors stating that contrary to the verdict read in court, the jury had unanimously voted to acquit, vacated in part on other grounds. United States versus Stauffer, affirming changing verdict on count where post-verdict interviews of several jurors determined that the jury had intended to acquit. Bluford and a juvenile both turned on lack of finality, not form. The four-persons report prior to the end of deliberations lacked the finality necessary to amount to an acquittal. quite apart from any requirement that a formal verdict be returned or judgment entered. There is no serious question here regarding finality. The affidavits are based on post-trial statements, reflect a clear and ambiguous decision that Miss Reed is not guilty. This is not a case like Bluford where the jury continued deliberations after allegedly reaching a verdict, and there is simply nothing tentative or conditional about the juror's post-trial statements. Juror B texting, it was not guilty on second degree. No one thought she hit him on purpose or even knew that she had hit him. So this juror is saying that the jury didn't even think that she knew that she hit him if she had. Intermediary C relaying juror C's statement that there was no consideration for murder too. Juror A told me that the result of the deliberations was that the jury unanimously agreed that Karen Reed is not guilty of count 1, second-degree murder. Juror A was emphatic that count 1 was off the table and that all 12 of the jurors were in agreement that she was not guilty of such crime. Juror D explained that the jury reached not guilty verdicts on counts 1 and 3. Juror D, without hesitation, said in substance, every one of us will agree and acknowledge that we found Karen Reed not guilty of counts 1 and 3 because that's what happened. Juror E stated that he or she decided to contact me to provide information about the results of the jury's decision-making following deliberations. Juror E explained that the jury was unanimous on 1 and 3, that Karen Reed was not guilty of those charges. The foregoing was corroborated by 2 voicemails received by the prosecutor stating, it is true what has come out recently about the jury being unanimous on charges 1 and 3. One juror expressly stated that the agreement persisted after the jury was discharged. Juror D explained that after the jury was excused and aboard the bus, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen Reed on counts 1 and 3? In these circumstances, the Commonwealth's unsupported suggestion that jurors may have changed their mind is purely hypothetical. The post-trial affidavits are more than sufficient to entitle the defense to an evidentiary hearing. See, Bev wouldn't even agree to an evidentiary hearing, which, how is that acting in the interest of justice? If these jurors came forward on their own and she is denying an evidentiary hearing because someone's freedom and someone's rights, constitutional rights, are in jeopardy, why wouldn't she act in the interest of justice and allow this evidentiary hearing and call for this evidentiary hearing? Why wouldn't she do that? What's the problem? If there's insufficient evidence to rule that the jurors reached these verdicts, then okay, then so be it. But at least hear them out. That's the argument here. Why aren't you hearing them out? If you're acting in the interest of justice, why aren't you hearing them out? Why aren't you investigating this? Because this is a hell of a thing. This is not an everyday thing that happens where jurors come forward after a mistrial is declared and say, hey, wait a second, something happened here and you need to know about it. That's not a very common thing to happen. So the fact that she's failing to even investigate this tells me all I need to know about her. There's nothing fair about that. There's nothing impartial about that. Impartiality even means seeking impartiality, meaning beginning the process to get to impartiality. Like, why not just simply call for this evidentiary hearing in order to reach a point where you could say I was absolutely impartial here. As a judge, I was absolutely impartial here. But your action dictates, Judge Bev, that you're not impartial. Because you wouldn't even hear the defense out. Not only wouldn't you hear the defense out, you would not hear the jurors who independently came forward out. They have nothing to gain. They have no skin in this. So why wouldn't a judge hear them out? If she was acting in the interest of justice and if she was impartial. An impartial judge would absolutely hear these jurors out because the jurors are impartial. Aren't they? I mean, that's a bold move, but that's if they can prove something. If they can get into what Cherry is saying. See, I don't need the kind of proof that Cherry's talking about in the chat to make this determination. Everything that I just explained is proof in and of itself. Her actions are proof. For me to call her corrupt, I feel perfectly justified in doing so. Now, if you want to charge her with a crime, then yeah. You know, if you want to put her on the witness list, you know what I mean? Like, you better come correct, you know? But, you know, my license to practice law is not at stake here. You know what I mean? I could sit up here and say whatever the fuck I want. And for the reasons that I explained in detail, again, I feel perfectly justified in saying that I believe Judge Beverly Cannoni to be absolutely corrupt and absolutely partial to the Commonwealth. I absolutely believe that. Without even a doubt in my mind, a shred of doubt. And that is due to watching her actions since pre-trial. Facts. Will got a license from Costco. I'll allow it. Now, this is stuff that yeah, let me just yeah, I think that's all I'm gonna. They're basically just go into why it's her rights, you know. What's up, baby boy? Just a little bit. Just a little bit. All right. Phone lines are open if anybody wants to call in. Drago's doing great, Robin G. Thanks for asking. But yeah, I'm tired, man. I feel like you guys can feel my vibe. And yeah, I'm tired, man. Like Drago, like, first of all, like I've smashed like move goal records this month. And so and Drago just fucking stepped all over my face all night, which was I kind of liked it, but I didn't get to sleep much.
Call from Gina.
You're on. Who am I speaking with?
Clara.
Dina.
What's going on, my friend?
Jillian, it's good to hear from you. How you doing?
I'm doing excellent, but I'm just, I'm not surprised here in Massachusetts of all the fucking bullshit, corruption shit. I want the bomb to explode here and just all this shit just implode because they're just so disgusting.
Well, I think those Better letters are kind of just a strong indication that that's going to happen. I mean, you get Ken Mello on that stand in Turtle Boy's case, no less. Think about that.
I know.
That's going to be amazing.
I think we're just getting impatient with it. We just want it to happen.
Yeah.
So anyways, tomorrow night's the big Halloween party fundraiser.
Okay, right on.
And I can see that my visionary board didn't land you in Boston, so I've given up praying to that.
Yeah, it's not happening for that, unfortunately.
We're going to send some photos because I like I said, my Halloween costume is geared towards you. So.
Oh my God.
And it's funny. No, you will like it. It's funny.
Okay.
It'll make you laugh.
I'm sure I will. I like everything you do, Dina.
Well, come on. I'm keeping it classy now.
I am too. Don't you make
and
that. Don't you make that nasty. You better behave. I was being nice.
No, I'm calling to compliment you because I love when you explain everything. And I think some of your best shows are with Melanie Little. I love when you guys are on together.
Yeah.
It's amazing.
Yeah, I like doing shows with Melanie Little. Absolutely.
Absolutely. You guys should do more of them.
Yeah, she invited me up for when she was covering the Menendez thing, but I had already I planned this a few hours ago. I already had this all set up. So, and then we went over the press conference a little bit at the beginning, and then, I shared some controversial thoughts that most people didn't agree with, which, it happens, but
I haven't watched the beginning yet because I had to work all day because I have tomorrow off to help set up the Halloween party. So I'll do the replay because I always replay your stuff. So, but I'm gonna let other people call in. But I hope to see everybody there, and I'll have the frame for people to sign, and the frame's getting turned over on Wednesday to go up for a fundraiser for Karen.
Nice.
And pay attention to the live stream if anyone's streaming from the Halloween party, because you'll see what it's all about for the Galera.
Okay, Dina. Thank you.
Peace
Awesome.
out. Love you all. Free
All
Karen
right.
Reed.
Bye-bye, Dina. The great Dina. You're on. Who am I speaking with?
Hi, Will. It's Leslie. How are you?
I'm doing great, Leslie. How are you?
Well, I'm always on your channel and the other guys, but I usually just keep quiet. My screen name is Bougie, but my real name is Leslie.
Okay. Well, it's nice to meet you, Leslie.
Nice to meet you. I would like to ask, did or did not Bev agree with the all the attorneys together, I should say? Sorry, I'm on oxygen, but I get out of breath.
Oh, I'm sorry. Yeah, take your time, please. Yeah.
Did she or did she not agree to make some changes on that form before it went to the jury?
She did.
And she said she did.
Right.
But then she didn't show it to them. And then she was halfway down her steps and she turned around and said, "Oh, do you guys want to see it? I am an officer of the court." And they let it go. They said, no, that's fine.
I think you're right, because I remember that too, and I remember thinking, like, whatever came of that? Like, I remember her saying something, and it satisfied everybody, but I mean, whatever happened?
I don't. Well, she's just so dirty and corrupt,
right?
But I kept about that, and I was like, I know, I could never find it. I went back trying to, go through some things, but I couldn't, and I was just like, you know what, this is bullshit. I absolutely remember her saying, "Or do you need to see?"
Yeah, because she defended herself and tried to drag Yannetti into it, and Yannetti was like, "No, Your Honor, I've never seen anything like that," because he's local, And then she gets pissed off. Like she literally gets mad at this, feels
Right.
humiliated, takes it out on Karen Reed and says something funny, Miss Reed. Right? Like, so I mean, that totally happened.
She's got to go with the rest of them. She just has to be lumped in with the rest of them and lose her job. Lose her judicial whatever.
I mean, the thing is like that probably won't even happen unless the feds got something on her,
Well,
But
I truly think the feds are going after what's his name? Your DA, what's his name?
oh, Morrissey? Yeah, for sure.
Morrissey. I
Yeah,
think
that
they're
dude's
going
hands
after
are
him.
so dirty. Jesus. That guy, I mean, come
Yeah.
on. Like, he just fucking hired Whitey Bulger's defense attorney to prosecute an unwinnable case, dude. That
Yep.
screams dirty.
Yep. And I think that the FBI is trying to get as many of the dirty ones before they get rid of him.
Yeah.
And I also believe that the reason he insisted on bringing these charges to the table, because he knows they're bullshit and it proves that she's not guilty, is because he's trying to figure out how much the FBI has on him.
Yeah. He's been trying to figure out what the FBI has on him. He's been
Stupid, I think.
I wish I knew. It's like that scene in Wolf of Wall Street, like it's just he did it in those letters, where remember DiCaprio was sitting there with the FBI guy on his boat and he was just like, yeah, I just for the life of me can't figure out what you're investigating me for. Why are you investigating me? I don't understand.
Oh my God, it's too much.
Yeah, that's except he did it in writing.
Yeah. I hear your phone going, so I don't want to hold up. Thank you for answering.
All right.
It's too much to write out.
Thank you so much, Leslie, for calling. I appreciate you.
All right. Thank you. Have a great day.
All right.
Bye.
Bye-bye.
Call from
You're on. Who am I speaking with?
Quack Quack.
Quack, quack.
Hi, Will. It's Helen.
Hi, Helen. Quack, quack, Helen.
How are you? Yeah, Quack Quack. It's Helen, the crazy Brazilian lady.
The crazy Brazilian lady. Okay.
I was thinking today. I know Auntie Bev is corrupt, and I know what's her problem.
Okay. What is it?
When she was a kid, she was always humiliated by every other kid, and now it's her time to show I have the power.
You think?
I
mean, that would be Occam's razor, wouldn't it? Yeah. If you applied Occam's razor, if you apply Occam's razor, that would be the most simplest, answer. You know what I mean? Like, it makes sense.
I have the power. You do what I say.
But I don't think that that's the case. I feel like there's some other. This isn't I don't like Alan Jackson, so I'm just going to be spiteful. That's not what this is. That's what you're saying. That's what that would be a result of. But no, I feel like she has connections and she is at least biased towards the Commonwealth due to the McAlbert connection. That is my personal opinion.
That is 100%. But that's one of her problems. I feel that she acts the way she acts in court. That is so unprofessional.
Oh, okay. You're talking about her actual, like her behavior, like when she was like, something funny, Miss Reed.
Is it funny, Miss Reed? And another thing that I was thinking, didn't she say she had to go? She couldn't make to court because she had to teach law.
Because she had to what?
That she has to teach law some school somewhere.
Oh, I missed that. I don't know. I must have missed that.
I don't remember if I recall correct. Can you imagine every school now teach how to not act like Meatball and how to not act like Auntie Babs? That is gonna be hilarious.
Hilarious. I agree.
Yeah, no, hey, I'm sorry. That is a joke. I'm sorry, Will. Okay,
no, you're good. Helen, we love you, Helen. Thank you for calling.
Love you more. Bye.
All right. Bye-bye. Oh, I missed the other caller. Dang it. I was trying to catch the other caller. Hey, Jay and Yannetti highlight Bev's insecurities of her failures, and she has a big ego problem and doesn't like being upstage. Exactly. I mean, in a nutshell, that's exactly it, Olivia. You nailed it.
Call from
Tiny Wood.
You're on. Who am I speaking with?
Hi,
Hi.
this is Tiny Woods.
Hi, Tanya Woods. You might want to turn me down in the background there so that
I did. I turned it off. I'm sorry.
okay. No, you're fine. You're fine.
No, it's Tiny Woods.
Tiny Woods. Piney Woods. Piney Woods. Okay.
TKO.
I remember Piney Woods. Okay, what's up, Piney Woods? Long time. How you been?
I'm good. I just wanted to call in because of the appellate documents you were going over.
Right.
And they've set a full panel in the appellate division. And I think the reason they have is because it's such a novel issue. And I really have faith that the appellate judges will actually look at it and at least order a hearing with the jurors.
Right. I mean, anybody who's acting in the interest of justice is going to do that. Like, I mean, the Commonwealth did not propose a good enough argument as to why that shouldn't happen. They just simply didn't. So
no, and it's really important to point out that our provision against double jeopardy is one of the big ones. It's definitely in the top 3. So it's a constitutional rule. It comes from England.
right.
I mean, the first time they talked about this was, Jesus, I want to say, one of the people in the court of Henry VIII.
Now, for those of you who don't know, Piney Woods has called here before. Piney Woods is a retired attorney herself, so she knows what she's talking
Oh, I
about.
went back to work, Will.
You went back to work?
I did.
I love
got
it.
me so fired up.
That's
I went
crazy.
Back to work.
That's amazing. Well, good for you, man. Piney Woods went back to practicing law because this case inspired her to do so, y'all. That is absolutely fantastic.
Yeah, I'm thrilled. But I'm working with some ladies I helped train years ago.
Nice.
I'm just the old grandma in the office. So
Yeah, but I mean, I bet it's pretty cush though. Like if you trained them, they look at you and they got a lot of respect for you, and it's just like they're making life real easy for you. I bet, right?
well, it's nice. It's
There
good
you
to be
go.
back at work.
That's nice because I mean, you earn that respect. You're the OG. They got you. I love it.
Yeah, but I've been so upset about this potential double jeopardy violation against Miss Reed, and I think it's really important, and it looks good for her that they've adjourned a full panel to hear this, and I believe they hear it on the 5th of November. Is that right?
Yeah, the 13th, I think.
The 13th. For some reason, I thought it was the 5th, but okay.
I could be wrong too. I don't know.
And I think it looks good, at least for a full and fair hearing on the matter. You don't have to go into the jury's
It's the 6th.
deliberation
Lamassu
to find
says
out
it's the
what
6th. Yeah, everybody's
It's the
saying
6th?
everybody's saying the 6th. Okay, thank you.
I thought
guys.
it was the 5th or 6th. Yeah, okay.
Okay, Keith.
But
Dang. Keith is spamming my
I just
chat with
feel like,
six.
oh, I just feel like it really looks good for her, at least to get the hearing and the statement of the jurors. If not a reversal. I mean, as defense brief pointed out, there really wasn't a chance for them to do anything for their client at risk of doing something against their client. And there was I don't know, not many seconds before she just went mistrial.
Right. Yeah, no,
So,
I mean, the fix was in, Piney Woods. The fix was in. Come on now. Come on.
I don't even
Well,
know if it's a fix, if it's not just pure incompetence. I mean, obviously there was bias there, but
I would
mean,
play devil's advocate and be like, okay, and entertain incompetence with you. I would, except if I didn't know everything that she did prior to that. You know what I mean? If I didn't watch her for
yeah.
months make
Oh,
bad
I did. I
decisions
watched
with
every day. Yes.
you know what I mean? Like really common sense, like hold on, like why wouldn't you do this? This makes sense. Like it reminds me, there were so many moments of Judge Bev, like where I was reminded of the movie Casino. Remember the movie Casino where Robert De Niro
Yes.
he goes in front of the gaming commission, right, to get licensed to be
Right.
to run the casino, right? And there was a senator and there was all these, you know, and he thought for sure he was going to get a fair hearing. He thought he was that was the whole thing. And then before the shit even started, they were pretty much like, yeah, I'd like to go ahead and motion to deny Mr. Rothstein his license. And the eyes have it. And then he's like, "What the fuck, dude? Are you kidding?" So, like this, and I'm seeing this happen with Bev. Like, wait a second, like, how are you just completely dismissing this argument? And then you justify the shit in emotion as if you just didn't hear or read anything that the defense even said. You know, like the defense's argument has substantially, significantly, and consistently been more compelling than the Commonwealth's arguments on any of the motions. I mean, am I wrong?
Yeah.
You watched it?
No, you're. I watched every day. I watched all the
Right.
pre-trial and every day of trial, all day. And I went into it not knowing anything. I just went into it. Somebody that practices on the East Coast called me and said, "There's a trial coming up. You need to watch it." I mean, I didn't know anything. I didn't know the rumors. I didn't know anything about Turtle Boy or any of that. I didn't know anything.
And as an attorney, you sat there and went, "Wait a second, what's going on here? How does that
Where's
work?"
the evidence? I mean,
Right.
about the third week, I was like, where is the Commonwealth's evidence? They haven't presented any. I know that Officer John O'Keefe is sadly dead, and I know it was snowing, and that's all I know. I mean, by the third or fourth week, I was like, that's all they proved.
Right. And then they explained the chain of custody of evidence and they have no explanation for it. It's just, oh, it was in the trunk of my car for a while and then I brought it in paper to dry out and you know, they didn't log anything. It's like,
that should never have been admitted at trial, which is one of my first
right. Like the evidence
to Beth.
the evidence they claimed to have wasn't evidence.
Well, it wasn't proper evidence. I wouldn't
Right.
let it in.
Right. I mean,
And
just from the beginning, yeah, a fucking leaf blower, really, you know,
and then the ME,
Stop and
who
Shop
I think
bag,
is gonna
red
give-
Solo cups.
Remember when the ME came on and I thought, okay, she's going to give evidence. And then
Right.
she said, I can't even rule it's a homicide.
Right.
And his injuries are as consistent with having been in a fight. And I'm like, oh my God. That's an element of their case. They have to show it wasn't homicide.
Right.
Oh,
Right.
it just infuriated me.
Oh yeah. Yeah. Like and it was crazy because I gave the Commonwealth the benefit of the doubt in the sense just for the same reason that Karen Reed has faith in the system that is still trying to railroad her in using it fairly to try to exonerate herself. You know what I mean? Like the same faith in the system that she had, I had when I'm reading the documents in this case and I'm going, this is crazy. This is not right. But let's see what happens at trial because maybe there's a smoking gun that I'm just missing. You know what I mean?
No, you weren't.
And then nothing. Like they just simply didn't deliver
They couldn't
any
prove every element of their crime. I mean, they couldn't prove that it was a homicide. That it was an absolute, pardon my language, but it was a shit show from top to bottom.
Totally.
And the only good lawyer that I saw was from the defense side.
Right.
Unfortunately,
now this guy's gonna be good. Like Hank Brennan is gonna be. He's gonna be impressive. he's going to be impressive, but the problem is that his case isn't going to be impressive.
No,
He's going to
and
be
the case
impressive trying to sell a case
hasn't
that
gotten
isn't
any
there.
better.
Right. He's
It-
gonna
it
he's gonna
hasn't
try
gotten
to
any better.
razzle dazzle the jury. That's why Michael Morrissey brought him on, so he could razzle dazzle the jury with no evidence. You know, play the
Yeah.
whole misdirection.
Yeah.
You know what I mean? Like that's their method, is misdirection.
And his motion for the phone records of Miss Reed's father are outrageous, but they kind of open the door for defense to make motions for all the phone records of the McAlberts.
Right.
And that's good. So that's it's a win. That's kind of a win.
Yeah, it is. Hopefully, I mean, I hope that happens, but yeah.
Oh, I know you've got lots of callers. I just wanted to say, I really hope that one court in this country would say, yes, our Constitution prohibits double jeopardy. And
yeah, just
so we're not
somebody
gonna let
speak
that
up.
happen.
Like, yeah, this is crazy that there isn't like an outrage over this, like nationally. It's mind blowing to me.
There is among lawyers. I mean,
Right?
all
Yeah.
of us are going to go, what?
Right.
And I'm kind of a constitutionalist, so
Yeah.
I'm big on the Constitution.
Then you're in good company.
So I just feel like, geez, if we can't make sure that her protection against double jeopardy wasn't violated, then what are we doing? What are we doing in court? And
right.
I sat on an appellate court for a while, and they have a lot of power. And I'm just hoping, praise be, that they look at it the right way.
Yeah. That's all we can hope for, is that the appellate court is on the up and up. Because all they're asking is fairness. That's all they're asking.
Yes.
They're not asking
Fundamental fairness.
Right. They're just saying,
fairness.
like look over, just review it. Let's have an evidentiary hearing. At least hear the evidence here. You know, but the fact that she's refusing to do that is very telling.
I think so too.
Right.
It's scary.
I agree.
But I don't want to take up your time and all evening and so you can get some more calls, but I just wanted to call in and say, go appellate court. I really think
I love it.
She has a shot.
Yeah, me too. We all do. So yeah, thank you. Thank you so much, Piney Woods. We love you.
Oh, I love you too, Will. Y'all
All right.
in chat. Okay, bye.
Bye. Piney Woods. Piney Woods. Piney Woods.
I think we got a super chat. I think we got a super chat. Super chat. I think we got a super chat. I think we got a super chat.
Karen Reed is innocent. After mistrial was called, jurors left the room, and there was a hot mic moment where you hear someone say, because we didn't change the form. Did anyone else catch that? I think I remember something like that happening. That merits some more looking into. Plevin's shit-eating grin. Thank you so much. Bev is in the meatball sandwich. Can't wait for her burner emails to come out. Oh yeah, interesting. Let's see if that happens. And I missed all these calls. Sorry, I was reading super chats. Y'all gotta wait.
Call from.
You're on. Who am I speaking with?
Hi, Will. It's Amy.
Hi, Amy.
How are you?
Fantastic. How are you?
I'm good, thank you. I actually just wanted to touch on one thing. So I've been thinking about this all day. So Howie Carr is kind of a genius, because whether or not he had a good source for the whole Auntie Bev not being the next judge, he forced them to put it on record that even though she should be moving around, she's not. And I think it's like so awesome that they just keep doubling down on how
that's a
ridiculous
good point.
they are.
That's a good point, because like they wouldn't have responded. They would have just let it go under the radar. but now there's a public statement put out there as a response to Howie Carr's post. Good point.
Not only that, but immediately.
Right.
Like, they dropped that shit immediately,
Right.
which was like they're constantly on the defensive, and the more that they do publicly before the Supreme Court, we go in front of the Supreme Court, the better it looks. And like, I was thinking about it this morning, and I'm like, that is so good. Like, because it's not just coming from, you know, what they claim to be bloggers. It's coming from, you know, I grew up in Boston,
Yeah,
and
man.
it's like, it's Howie Carr is like a fucking
He's a legend,
Excuse
dude.
my language.
Yeah.
I mean, like, I remember as a kid in high school, like in the 90s, studying him. Like, you know, I took current events, and they would talk about like him going after Whitey Bulger, and like then when Billy Bulger
Wow,
got like
you guys
all
were talking about
involved,
this
like,
in high school?
in high school.
That's
Like, he's
awesome.
been around forever, and he's well respected. So like, for him to come out the way he is amazing. But like, for that specifically, I thought like, that is genius, because regardless of the source or not, they were so paranoid they jumped on it. Like, we need to respond to this, which they really don't. You know what I mean? They don't have to, but they keep doing it. And it just shows how fucking shady they are. And I'm like, I just wanted to talk about that. That's all.
Yeah, right on. No, I appreciate it. That's fantastic. I
Well,
agree
I
with
hope
you.
you have
You're
a-
right.
Yeah, I think it's awesome. The more that they put their foot in their mouth, we'll take it, because free everybody. That's what I like. That's how it's getting. Like, you don't even have to say them by name. It's like all these people, like, free them all.
Yeah, man. Free Richie Schiffer. That dude is
Oh,
awesome,
that-
man. Absolutely. Free
that-
Karen Reed. Free Turtle Boy.
That guy's hilarious.
I
Yep,
love it.
Free all of them. All right.
Yeah.
Well, you have a great night, sir. I hope you take care, and say hi to your cat for me. That's so cute.
I will. I will. Thank you.
All right. Take care.
All right. Good night.
Okay. Bye.
All right, folks. No more calls tonight. I want to direct you guys over to Brandy Churchwell's chat. Go in there. Let her know it's a Glare raid. I know she's gonna have Turtle Boy on, and yeah. I do have to go. Normally, I like to go 3 hours with these things if I can, but Clubber's hungry. I gotta feed him. He's like growling at me. So he's not growling, but he's just like, dude, what the fuck? So yeah. But guys, I want to thank you guys for everything, man. Thank you guys for all of the support. Thank you guys for all the new subscribers. Been getting a lot of new subscribers, and I'm really grateful for that. I hope you guys are really enjoying the channel. And thank you guys for hanging out with me. And spending your Thursday afternoon with me. I'm really grateful to you guys for that. And if you haven't hit the like, please do so. I'd really appreciate it. Yeah, you guys are absolutely amazing. I really appreciate you guys. I think maybe, I know Tuesday at 6:30 p.m. I'll be going live on Resistant to Silence. And I will be hopefully it's in its conceptual phases. Now check it out before I actually log off real quick. Last night I did a live stream with it's bar none my favorite channel. It is the Hannibal and Monty show, and it's not true crime related in any way, shape, or form. They're just a couple of really cool, very creative, funny guys, very intelligent, and we have great banter, and they're just my favorite people to talk to on live streams, man. And I have never had them on this show, and so I'm gonna have them on at some point. We just have to agree on a time, but I'm gonna have them here, and I'm going to school them on the John O'Keefe Karen Reed case. So this this is going to be fun and interesting, because I really can't wait. And these guys are these guys are just great. So what we did last night was we just reviewed 3 movies. They gave me a homework assignment to watch 3 for in the spirit of Halloween, to watch 3 black horror movies, predominantly black casted horror movies. We watched Get Out. We reviewed Get Out. We reviewed Candyman, the new one, the 2021, and we reviewed Leprechaun in the Hood. And it was fun talking to those guys about those movies, man. Yeah, so if you guys are interested, go check it out. They're called the Hannibal and Monty Show. The post for the live stream is still in my community post. You might have to scroll for a second, but I posted it yesterday or the day before. But the link for that is in my community post. Make sure to go check them out. I had a great time, and it's incredible to me that these guys don't have just like hundreds of thousands of subscribers. It's mind-blowing to me. It makes no sense to me. But such is the mysteries of YouTube. I have no idea why the fuck I even have close to 40,000 subscribers right now. So anyways, guys, you guys are absolutely fantastic and you mean the world to me. And it was a pleasure spending my afternoon with you guys. Thank you guys so much. I love you very much. And we will do this again very soon, my friends.